Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another episode of the Colorado Trial Lawyer Connection podcast. Super excited this week to have Clay Wire and Jason Wesoky from the law firm of Ogmore Mim. And what I'm really excited about this episode is this is a very sort of tantalating, very unique fact scenario that deals with a breach of contract. And normally people think breach of contract, that doesn't seem very tantalizing. But in this case, it was. And I'm really curious to talk to you both about how you formulated the story of this case and presented it in a way that made jurors care. But before we jump into that, Clay, let's start with you. Tell us a little bit about yourself. How did you come to be a trial lawyer?
All right. Well, so I grew up here in Colorado. I'm one of the few Colorado natives around still. I grew up in a little town just past a little town called Red Feather Lakes, up past Fort Collins. I don't have any connections to law, really. My parents were a bit of hippies. We lived out in the middle of nowhere in a log cabin. No electricity, no running water. It was a very weird way to grow up.
Wow.
But I didn't have any real connection to a legal community, right? I didn't have any mentors or anything like that. So it wasn't even on my radar for a long period of my life. I ended up going to college to become a journalist. And so I did all of that. Then I got interested in poli-sci and ended up double majoring in journalism and poli-sci. It turns out, though, that I was making more money bartending than I would either being a political scientist or a journalist, and so decided to go to law school.
Yeah, where did you do your undergrad? In my mind, I'm thinking it had to be Boulder, just based upon this story. But am I wrong? Was it Boulder, or where was that undergrad?
I was at CSU up in Fort Collins.
Oh, okay, I guess it makes sense with Red Feather Lakes.
Yep.
All right, so you're at Colorado State, get your undergrad degree, and then where did you go to law school?
So I went to DU,
Okay.
kind of stayed in state again for that. But it was really at that point, I think like a lot of law students, I had a false conception of what being a lawyer was like. I wanted to do international law. Wasn't really sure what that meant, but I knew I wanted to do it. And Ved Nanda, who has passed, but was running the international law program at DU, made it one of the top programs. And so wanted to go there. Turns out international law in Denver is pretty limited.
That's shocking.
And constitutes mostly just reviewing a whole bunch of contracts and that sort of stuff. So it kind of started to be less of a focus for me. I ended up clerking for the Bendinelli Law Office,
Yep.
PI firm here in town that
Yep.
has had some really great victories, and got to do just an amazing amount of stuff. They were super supportive of their clerks, and so I was able to do a lot of actual trial lawyer work from the back end as a clerk, and worked with Joe Lapham, Becky Albano, some great lawyers there.
Yep.
And so got interested in doing more trial work, and then did a clerkship at the Colorado Court of Appeals with Judge Nancy Lichtenstein.
Okay.
I graduated from law school in 2009, which was kind of the height of the worst point to graduate from law school. There's probably, I don't know, 5 or 6 jobs on the CBA job posting list. And one of them was Starr's Mim, Michael Mim and Elizabeth Starr's firm. And so I just kind of threw my resume out there. And I was lucky enough to get hired there to do a lot of employment work, employment and constitutional law work. They had a partner at the time, Buka Smith, who was doing a lot of that work. And so I just kind of fell into it, frankly. It was really good situation, good people to work with. And I ended up doing some really important work right off the bat.
Yeah, definitely a great firm that you found yourself sort of landing with. So were you at then, well, I guess the Ogmore Mim predecessor, was that 2009, 2010 timeframe?
Yeah, so I started with Starr's Mim in June of 2010 after my clerkship.
Okay.
And then almost 15 years later now, I'm still with the predecessor firm, right? We went from Stars MIM to MIM when Elizabeth Stars went on the bench, and then we merged with Ogborn, Summerlin, and Ogborn, which is Mike and Marie Ogborn's firm. And then we've been Ogborn MIM for the past 13 years now, almost.
So then that first job, were you in the chancery?
No, we at that point, God, I can't even remember what the name of the building was,
Okay.
but
Because
yeah.
I remember when we first opened our firm, which I believe was 2008, across the hall was the Agbor Mem predecessor in the chancery. And
Oh,
so we just
really?
had this little tiny office on the floor and saw this great, amazing law firm doing these amazing things, and hoped someday to do such great things. One more quick question before we ask Jason how you came to be in this amazing world of trial work. Before you went to work for Bendinelli, did you have an interest in doing trial work, or was it only by happenstance you go to work there that your eyes are open to this wonderful world of trial work?
I think that by that point, at my second year of law school, I had started to realize that there was this split, and it sounds kind of naive now, right? Of plaintiff, defense, those sorts of things. But I had no context, right? So I went into law school with very little information about, what this field looks like other than civics classes, that sort of stuff. And so I think what I came around to was the realization that there's no way in hell I could ever be a prosecutor or a insurance defense attorney. They're just not things that jive with my personality and why I'm a lawyer, right? I think what interested me about international law, and frankly, this is coming a bit from the journalism perspective, is I saw it as an opportunity to do international human rights work, that sort of stuff, and stand up for the little guy who's oppressed by large governments and horrible situations, and advocate for individuals. Turns out that's a very small percentage of what international lawyers do, but I saw that outlet in doing trial work. And I think working at Bendinelli, it really opened my eyes to, you can have an impact on individuals' lives doing trial work. And I retain kind of a desire to do civil rights work from just kind of who I am. And I think that ending up at Stars MIM doing 1983 cases right off the bat.
Wow.
We had a huge whistleblower case and a Section 1983 case against a police officer in a police department from a rape by the police officer. And
Wow.
so jumping into those types of cases right off the bat, I think showed me that there's space to really have an impact on individuals through doing this work, and it just stuck with me.
So I lied. I have one more follow-up question. And how does your background in journalism, does that help you find the story or tell the story? Because I've sometimes struggled with, here we are, we're supposed to be these trial lawyers and we're supposed to be these great storytellers, but I don't know if I'm a good storyteller or not. And I just wonder if your journalism background sort of assisted you in being able to really trim down the fat to tell a compelling story, which, I'm getting ahead of myself here on the case here. Seems like you guys did masterfully in this case.
I think what it did is it forced me to think about the inverted pyramid, right? Of
I don't even know what that
storytelling.
is. Inverted
So,
pyramid.
so in journalism, right, you're taught the inverted pyramid. Your lead and the way that the story starts is the most important facts at the beginning, right? And then because you have to be conscious that news is a consumable product, right? And so headlines are very important, subheadlines are very important, and then your lead, that first paragraph, that tells as much as the story as possible in a compelling way that has somebody read the rest of the case.
Got it.
And so I think conceptualizing both writing and standing up in front of a jury in that sense of, how can I do an elevator pitch in a way, a concise, straightforward way to tell the story of this case in a way that encapsulates the important pieces that I want the jury or the reader to know right off the bat, I think has helped. I will tell you, though, it's always a fight, right? I mean, we get so in depth in our cases and we get so wrapped up in the minutia that I'm always having to go back over my own work, because I end up getting wrapped up in something that I may think is important, but at the end of the day it's only important because of a very tangential legal issue that I find interesting. And so that editing process, I think, has helped as well.
And I imagine your time at the Court of Appeals reinforced the importance of trimming the fat in the legal writing aspect of the work you do, I'm sure.
Yeah. And I think, I'm a person who tends to write, when the page limit is 10 pages, I'll write 15 pages and then edit down from there.
Okay.
And that's just kind of the way that I've always written. But absolutely, it's if I'm not able to get my point across clearly and concisely, then we lose.
Yep.
And so it's always that battle.
All right. So Jason, tell us a little bit about yourself, your background, which is fascinating, and how it is that you came to be a amazing trial lawyer.
Well, thank you for the adjectives. I don't quite claim native status. We did move here when I was 1 year old in 1977. So close, but not quite. And I did just give away my age. I grew up here as well. My dad is an attorney, or he's now retired. He mostly worked his career here, either for the city attorney's office or the attorney general's office here. So, I grew up obviously with the legal world being part of my world. But as those listening or watching know, government attorneys don't get paid well. So while I did attend Cherry Creek, hold for booze, I was not gifted a BMW on my 16th birthday. But I always knew I wanted to be a lawyer, and some of that was the natural selection process of not having any other skills. I went to college knowing I wanted to be a lawyer. I went to undergrad at Miami University in Ohio. As we like to say, Miami was a university before Florida was a state, so you shouldn't confuse them, but people do. And I went in as a poli-sci major, right? Like that's sort of the track. And I took poli-sci 101 or whatever it was, and I hated it. So I swam in college, and so I was talking with a senior who was going to law school, and I was like, this sucks. And he said, you don't have to be a poli-sci major. You can major in anything. So just do what you like.
Yeah.
So I changed my major to creative writing, which obviously being a good writer is a huge asset as an attorney. So I did that. Then I went to law school at the Catholic University of America, Columbus School of Law. It's the other law school in Washington, D.C. And I went there because, as many, really intelligent people do, followed a girl to my place of education. But, it all works out in the end, even though she did dump me right as I arrived in DC. So, a good start. But I did meet my eventual wife my first year in law school anyway. So it all
worked out. It all worked out okay.
But DC is a great place to go to law school. And I was there during a particularly crazy time with both Bush v. Gore and 9/11 while I was living there. So it was interesting. I mean, literally, I walked by the Supreme Court to get to my apartment every day. So there'd be huge protests, some guy carrying a giant cross, somebody holding up an anti-circumcision sign for some reason, all the interesting protests. And then I was going to stick around in DC for a while, but that didn't work out. My wife, or not yet wife, but she moved to Colorado. Her family lives here. And so I moved back as well and started work at Perkins Coie here, which had just opened up their Denver office.
Yeah.
Because my view of the world was you got to, go to the big firm and eventually be a partner there. And that's all I ever kind of thought of or wanted other than a federal clerkship. So I did that for a couple of years, and I managed to get a federal clerkship on the 10th Circuit. A new judge had been appointed, Judge Timkovich, with whom my dad had worked at the AG's office. And they actually, those who have been around in Colorado for a while will remember the Amendment 2 case, nothing to do with guns, but having to do with Colorado decided to constitutionally essentially discriminate against LGBTQ folks. And that went up to the Supreme Court. My dad did the trial defending the law, and Judge Timkovich was a Solicitor General at the time. He did the Supreme Court argument on behalf of the state. So, there was a tie there, right? Certainly got my foot in the door. And after that, I worked for Brownstein. Again, just sort of like that typical big firm track. I grew up a little bit under Stan Garnett, who eventually became the Boulder district attorney. And
Yep. Yep.
his view of litigation was not the typical view of litigation for big corporate firms, right? I assume we can swear on here.
Sure.
His view was, fuck it, let's go to trial. Like, I'm not going to dicker back and forth with discovery letters and all that nonsense. Like, let's just go to trial and see who wins. And then, 2008 recession hit and a lot of layoffs happened, including myself. But during my time at Brownstein, I had actually done a case for Frank Azar's firm. He was a client of Brownstein, and we had a case where he was our client, and I guess I did a good job because when he knew I was looking for work, he said, "Hey, come join the firm." And I was like, nobody goes from Brownstein to Azar. Like,
I was just about to, there's a joke there somewhere. If they,
yeah, it was, so it was not a real existential crisis, but I did struggle with it. I mean, like, I've spent all these years like building the resume, doing really well, trying to get, on this track. So I asked a lot of people what they thought. My dad, my law school roommate, Judge Timkovich, and eventually decided that I'll take the leap of faith, and realized while there, although I was doing mostly class action mass tort stuff, that representing human beings as opposed to corporations was way more interesting and rewarding. So
let me just make sure I got it. So you did end up going to Azar, where you're doing mass torts, big. Were you on the wage claims with the Walmart case? Because I think maybe a lot of people don't understand the breadth and skill and knowledge that Azar brings to cases. So sometimes they might think, oh, it's, car crashes only, but there is a whole world of amazing lawyering that is going on at that firm. Was that your experience?
Yeah, so it's certainly like you've got the public persona and the public image, which, he's very much involved in, perpetuating. But yeah, behind the scenes, there's a lot more going on. I came in at the tail end of the Walmart cases. They were resolving and settling. So I got to fly out to a couple of objectors hearings. And so if people think personal injury lawyers are really kind of bottom of the barrel, which I know that's the public perception, it's absolutely incorrect, because the second that you get hurt, you got to call one of us, and you'll be thankful that you did. But, in a class action, you can object to the class action settlement, and it can hold up the class action settlement for years and years. So I had some involvement in that. But the main case I focused on, which was one that did not end up successful, was a wage claim against Hewlett Packard. And that was out in California in a district court up in San Francisco. So worked on that, and, eventually found my way to a firm called Darling, Milligan, Smith and Lesh, which was a very small firm. And I was, I think, the sixth or seventh attorney, mostly doing litigation, but a broad practice, and was there for 10 years. And then, I had done some cases co-counseled with folks over at Ogborn Mim, including Clay, referred cases back and forth. When time came for a change, they were the only people I called to see if they were interested. And, fortunately they were. And, I've been here, 3.5 years now. So
fascinating. You've sort of run the whole gamut with your father, 10th Circuit, because it's unusual, is it not, for attorneys to clerk for federal judges after they've been in the workforce for a period of time? Or does that happen, I guess, when you have a new judge that takes the bench?
Yeah, I mean, certainly it's not the typical situation. Judge Timkovich came on to the bench kind of in the middle of what is normally the clerkship cycle. And I had been out for a couple of years, and he was looking for clerks who did have practical experience because he was getting up to speed. And so that would hopefully accelerate that. So I was his second class of clerks. So in his first and second class of clerks, at least there were 2 out of the 4 of us that had been working for at least a year in the regular workforce. I had been working, a couple of years.
Got it. All right. Well, Clay, Jason, let's talk about this amazing trial that y'all had in Denver. Who wants to kind of give us the factual backdrop of what happened?
Clay's case, so you take it.
All right. So in this case, we represented Dr. Penelope Euchre. Dr. Euchre's got an amazing background as a geologist turned educator. Just kind of a very inspirational story. But, I think what's most relevant to this case and what's most impactful is her work with directly working with science students in elementary and high school. So she became a science teacher 25 years ago, 30 years ago, after a career as a geologist. And then from that became the leader of the entire science program for Arapahoe County School District, if I recall correctly. And then from there started a magnet school solely focused on STEM, science, technology, engineering, and math skills for Colorado students within Arapahoe County School District. And then from there became the executive director of the charter school that we ended up unfortunately suing, STEM school down in Highlands Ranch. And so she became an executive director there back in 2012 when the school had just been starting out and it was kind of failing. It wasn't doing particularly well either financially or from a student performance perspective. And she really turned it around. Right. And over a decade of being the executive director, the leader of that school, made it into just this incredible force within Colorado education. It started being, some of the highest performing students in the state, started being nationally ranked and recognized. They had, Kid of the Year on Time Magazine, things like that. And then, I think is all too common these days, STEM suffered a school shooting. Back in May of 2019, there was a horrible shooting there. And I think that, for the STEM community and for our client, that was a real kind of game changer. And, it forced our client to really commit to the school in her entirety and really, help the school through this traumatic event, be the school leader that she had always been from an academic perspective, but now it was also from a societal perspective and helping these kids who had been through this horrible traumatic event become successful students again. So she goes through all of that, and she's been the executive director at the school for a decade. And the school decides that it wants to start replicating. In other words, opening other charter schools within Colorado and maybe outside of Colorado with the same kind of curriculum, the STEM curriculum.
Let me jump in and ask a question about that, because so when you have a charter school, it is a public school. Is that right?
Yeah. And that's an important distinction, right? Because so charter schools are essentially these private, usually nonprofit entities that contract with a public school district, in this case, Douglas County School District, to run a school, to run a public school. They're this kind of unique entity where they're not purely within Douglas County School District. They have their own board of directors. They have their own budget. They have much more latitude on their curriculum. That's kind of the whole point of it, right? And where a lot of charter schools are focused on societal issues or things like that, or there's a specific reason for them being that separate and apart from education, what was unique about STEM and what Dr. Euchre did there is that this was a school that was focused on STEM, right? It was focused on, unique students who might not thrive in other situations, but because of the environment that she had built at the school, were exceeding all expectations.
And correct me if I'm wrong, but and I think that this becomes relevant on your case, I thought, is as a public school, then she's eligible for para. Is that right? And para, for those that don't know, is an amazing pension plan. Do you want to kind of explain to our listeners what para is and why, if you are eligible for it, it's a big deal?
Yep. So para is essentially it's the Social Security replacement for public employees. So folks that are employed by the state of Colorado, Denver School District, Douglas County School District, Cherry Creek School District, and a number of other governmental entities all fall under para. And what that means is that both the public entity and the employee contribute a certain portion to a guaranteed pension program, right? So it's as pensions kind of phased out,
Right.
this somewhat replaced it. And it's kind of this quasi 401k-ish, but pension-ish type of program where you can get a certain percentage up to 100% of your average highest salary as a public employee. And so it's a real big incentive for folks to take on these otherwise low paying jobs and work at them for an extended period of time. So Dr. Euchre's a part of this. And when she comes up and she's now been the executive director for 10 years and they want to expand the charter school network that they're developing, they offer her this position as the CEO of this network. In other words, she would kind of sit above all of the schools as they opened other schools, and she would be kind of the visionary leader of how are we going to, extend this STEM-based curriculum to all of these other schools.
Still as an employee, as a governmental employee?
Right.
Okay, got it.
There's a unique piece of para, though, that you can retire for para purposes, begin drawing your para benefits, and then return to work for a public employer while still drawing your para benefits, these benefits that you've been paying into throughout your decades-long career.
Okay.
And so she was at the point where that made sense for her. And so she goes through with this process that she had talked with the president of the board of directors at STEM about. And she signs a new CEO contract. That's this 3-year CEO contract that would have taken her out into this year, 2025, as the CEO of STEM schools as a charter network. She signs that contract, then she goes through with this retirement for para purposes. And then as a result of that, once a new president comes into the board and before her contract even starts, they take the position, STEM schools takes the position that, well, you've retired and therefore we're not going to honor your contract. It's a very simplified way of putting it, but essentially they refuse to bring her back as a CEO.
And were there ramifications beyond just the income during that contract period of time that she was losing? Or were you essentially filing suit just for the contractual benefits of that CEO contract?
We ended up at trial with just the contractual benefits of the CEO contract. Was there other impacts? Absolutely. Right. This is a woman who had dedicated her entire, the majority of her professional career to educating students and building up to this point where she could expand her vision for educating kids who, might not succeed anywhere else, but under the STEM program that she had built would succeed. And that's all ripped away from her. And so, the impact goes far beyond financial for her. The problem is this is a contract case, right? And we're dealing with a governmental entity. So because of that, we couldn't bring any tort claims against the governmental entity. And so we did have the contract claim, though, that got by CGIA, obviously, the Colorado Governmental Immunity Act.
Yeah.
And so we kind of narrowed it down. We had hoped to go after non-economic damages at trial. The judge, unfortunately, shut us down on that and only allowed us to go after the economic damages. But we were able to go after that, at least the economic portion of what she lost.
So educate our listeners, because many people might be thinking, well, wait, I thought Colorado was, a right to work state or whatever it is. You can get fired for any reason, anytime. Too bad, so sad, go find another job. So how is your client able to bring a claim for sort of sounds like wrongful termination or something like that?
Right. And so Colorado is an at-will employment state.
Okay.
And what that means is, the employer or the employee can end the employment relationship for any reason or no reason at any time without notice, so long as it's not for a designated improper reason, right? You can't fire somebody for refusing to engage in illegal conduct, or you can't fire somebody because of their race or religion, things like
protected class.
Right. Or
Okay.
protected activity.
Okay.
But that at-will status can be modified through a contract.
Huh.
If there's an employment contract, then written employment contract or verbal employment contract in some situations, that governs, right? And that can limit the ability of a company to terminate or otherwise change the terms of employment. What's interesting in this case is we didn't even get them, right? Because they refused to even employ her under this contract. So it truly was, there was a contract in place, they agreed to employer, and they refused to abide by those obligations. So it was a
What
much
was their
more
reasoning?
case.
Well, two questions. First, what did you have to prove? In other words, what did the contract say they were allowed to terminate the contract for? And what was their reasoning for not agreeing to go through with the contract?
Jason, do you want to jump in here and discuss that aspect?
Yeah, sure. I mean, so again, and we're talking about a written contract signed by both parties in March of 2022 with a start date of August 1st, 2022. So the contract was actually very simple. It's not a typical C-suite contract that's going to be 20 pages with a golden parachute and anything like that. It was a couple pages, and there were three ways to terminate the contract, two of which were irrelevant. The only one that mattered was by mutual agreement of the parties. There was no way for either party, including our client, like let's say, she just decided halfway through her tenure under this contract, she just didn't want to do it anymore. She can't do that. She was stuck in this contract like they were, unless there was a mutual agreement. And so the school, like Clay said earlier, when she said, look, I'm going to step away for a short amount of time. I'm going to have no involvement with the school. That's going to be my retirement so I can start collecting my para benefits. And then I will start this contract on August 1st. The school took this insane position, advocated by this other lawyer that was representing them at the time, that was just absolutely legally incorrect in our view, that, well, if you retire, then you retire, and that somehow acts as her not honoring or repudiating the contract. And so when she said, no, that's not what's happening here, and said before August 1st, before the start date of the contract, I have every intent to come back and start my job on August 1st under this contract, they said no. And our response was, where is the mutual agreement to terminate? There isn't one. We can get into sort of the Open Records Act and the Open Meetings Act things, which, really made it, in our view, impossible for the school to make a good faith, non-frivolous claim that there was a mutual agreement, but they did so nonetheless.
Yeah, so let's talk. What was sort of their in-court excuse for why they did what they did? And then what's the real story, and how did you find the real story?
I'll start briefly, and kind of let Clay take it from there. So the story in court was, you retire, that means you retire, and this contract is no longer in existence. And they claimed that somehow the para rules themselves prohibit a para eligible employee from agreeing in advance of a retirement to come back. Well, that's just not true. In fact, para documents specifically contemplate this, and the school had done this with an employee prior to Dr. Euchre doing it.
Okay.
The real story, which was discovered through core requests and other documents and witness testimony in trial, was that a lot of people, for whatever reason, despite her extraordinary success helping their children, didn't like Dr. Euchre. They said she ran the school like a business, and they thought she was overpaid. And it ended up being like a lot of stuff is high school all over again.
Right. And it's like the cooler talk of people. I'm just imagining these teachers or school administrators just sitting there talking smack, and then it just becomes this toxic work environment. And in my mind, I'm telling myself all kinds of stories of how this went down.
Yeah, and I'll let Clay take over on what was in the text messages and everything that prior counsel obtained through Cora, because it was like high school cliques. It was like Mean Girls.
Oh my God.
Yeah, and like Jason alluded to, I mean, a lot of credit goes to our predecessor counsel over at Lewis Roca, Angela Vichik and Paige Johnson over there, who represented Dr. Euchre right after she was terminated. They got right on it, and they sent out Cora requests, Colorado Open Records Act requests, to the charter school. And
before the lawsuit was filed, is that right?
Right.
Talk to us a little bit about that and the ability to use Cora requests pre-suit.
Right. So the Colorado Open Records Act, right, is the state version of FOIA, right? So Essentially, what the Open Records Act says is that any public entity who's conducting public business has to maintain all the records regarding public business and public finances. That extends to charter schools, who are public schools under public school districts. And so our predecessor council was able to request things like the text messages between the president of the board of directors and the vice president of the board of directors. Cora requested all the email communications between the board members who made this decision not to allow our client back about that decision.
I have a question about the text messages, because we have a system here where we can text our clients and it goes into our practice our software. Did they have that, or did they literally like take screenshots? Because I'm just wondering, you're just relying upon the honor system of two people texting each other to actually preserve that?
As much as we get into these battles with opposing counsel, right? Look, Eric Hall, who was on the other side of this case, a very, I think, very straightforward, honest attorney, right? To recognize that, look, there are these text messages, they exist, they're responsive. We're not going to hide them. We're going to deal with it straightforward. And a lot of credit goes to him of doing something that I fear that there are less scrupulous attorneys who would not have done. But at the end of the day, they did. They took screenshots the president took screenshots on her phone, and those were produced very quickly as a result of Cora requests.
I'm literally in shock. I feel like that would never happen in one of my cases, but maybe it's just my luck in the world. So,
well, keep in mind, it's got to be the governmental, work. So what, a lot of, particularly in the Attorney General's office here in Colorado, they are required to have two phones, like personal phone and, government phone. And if you do any government business on your personal phone, well, that is going to bring everything in your personal phone into the net of Cora requests.
Got it.
So, part of the problem here is, as Clay talked about, is this charter school has its own board of directors. It's not governed by the board of directors of Douglas County Schools. And it's a voluntary board. And, that obviously is a difficult position to be in. And they may not really have all of the experience that they need to understand, gee, you probably shouldn't text poop emojis about, somebody that you don't like, because it's going to be found out.
Wow.
Or it's going to be blown up as a huge demonstrative, and I'm going to be questioning you about what you meant by that poop emoji, which is something that happened in the case.
It's just fascinating. So you get, and I think I cut you off, Clay, because you were talking about the text messages and other information. I think that we were going to the real story of what was going on.
Yeah. And so I want to jump back to that real quick. Yeah. So we've used that in other cases, like civil rights cases, for instance.
Okay.
And sending Cora requests to police departments and other entities like that, right? That may be a target as a defendant. And it's not part of discovery. It's much broader than discovery, right? So you can ask for any public document regarding any issue. And it allows you to do kind of a pre-suit discovery in a way that's much broader than you might actually get at the end of the day.
Yeah.
And so I think, like I said, I think this case would have looked a lot different if Angela Vichik and her folks over at Lewis Rocha hadn't jumped on this immediately.
It sounds magical because you're not having discovery dispute hearings with your Cora requests. So,
well, and then, what ended up happening, right, is there was very little document discovery in the case because they had done such a good job in those Cora requests. And I think, like any case, I feel in my gut that there's stuff that we left on the table, right? I'm sure there was other documents out there that we could have gotten. But at the end of the day, there was enough. And I think that, we were able to tell a very compelling story of, like Jason was saying, a mean girl, which is exactly what our client called the situation on the stand, where she was being targeted by a group of board members who didn't want her around anymore. And they saw this as their opportunity. And they got really bad advice from an attorney who testified that they could just simply walk away from this contract that obligated them to employ her for 3 years.
So I want to come back for sure to the excuse of our attorney told us it was okay. But before I do that, how did you all formulate the theme and story of this case to make the jurors care about this? Because it seems it's fascinating. It's because I'm geeked out by it. Definitely a wrong has occurred here, but I'm a lawyer. Maybe I like these things. Our jurors, was there a concerned jurors like, well, so what? Go get a different job or something like that.
I could show you our war room, and I don't know if it's been erased, but we have this huge one wall that's like all dry erase, right? And Jason and I filled up that entire wall probably 3 times over trying to map out everything.
Yeah.
It looked like a crazy person doing drawing the string lines between 2 different things. But I think what we ended up doing, and we went through so many different iterations of this, and this is where I want Jason to jump in here in a minute on the focus groups, right? We found out that really people got that our client cared, right? They got her backstory of being a caring, compassionate teacher and educator, and that's pretty apparent on its face.
Mm-hmm.
What we needed to tell the story of is that she got set up, right? And that there was a motive here, and that this was a decision that was motivated by a desire to get her out of there, and that became our story. Right, because we had some amazing testimony from a former board member, from a couple of former board members, but one in particular that really told this story of how they tried to take advantage of this situation that shouldn't have in any way impacted her ability to return as CEO of the company. And so we learned a lot of that, I think, from the focus groups. So Jason, I don't know if you want to talk about the role of focus groups in our kind of.
Yeah, I'd love to hear how focus groups sort of help. It almost sounds like betrayal or some kind of word that evokes intense emotional response. How'd you find that?
Yeah, I mean, betrayal is, if you can find betrayal in a case, it is one of those fundamental human emotions that just triggers people. We all know that logic and facts do not drive a case. They are sort of the cars, thinking about a train analogy, right? Those are the cars carrying the cargo. The engine of any trial train is emotion. And we did a couple focus groups through Mojo Consulting. Reach out if you want to have your case focus group. But the first focus group we did was what we call just a perception focus group. And we give them a very general, neutral, maybe defense heavy slightly narrative of the case, and then just start asking open-ended questions, much like you would do during a voir dire if you had the time to do it, which you don't in Colorado, which is a problem. But one of the things that a focus group member said was, sounds like she was set up. That didn't come from us.
Wow.
That came from them organically. And we knew like there was some of that, but you don't want to look at the world with a conspiratorial lens. But when focus group members, just average Joes off the street, start looking at things and saying, "Geez, this just looks like she was set up," and then we had the evidence to kind of substantiate that, it really gave us a good insight into we can use that betrayal setup as our emotional engine. Clay alluded to one of the former board members, a gentleman named James Hardy, who, in my view, very courageously, right? Like, he's a former board member. He has no obligation to us. He actually quit at a protest when all of this went down back in 2022, because what he saw in his view was very problematic. He felt they were trying to manufacture attorney-client privilege where none should exist, particularly with an entity that is bound by the law to keep its meetings open to the public. And his testimony was not dynamic, right? This wasn't a Perry Mason moment. I really kind of had to draw it out of him, but he had sent a, 6-8 page single space 10-point font email to the board of directors long before any of this, got hot with lawyers, laying out what he saw were the problems. He sent it to the president of the board of directors and the other board members. And during trial, when we asked the president of the board of directors whether she read it, she said, I skimmed it. It was very long. You could see the jurors respond like, "Are you kidding me?" Like, this man takes the time and effort to lay out chapter and verse, and you just basically slough it off. It was that dismissiveness was sort of an undercurrent during the trial.
So who was your first witness? Was it the board member that wrote the 6-page letter, or was it the president of the board? It had to have been one of those two people.
Right, and it's the former. It was the board member who resigned who sent the letter. And look, every great trial lawyer knows you need to start your case impactfully, but also with a witness who's relatively uncrossable or unimpeachable.
Sure.
Right.
Yeah.
The defendant, right? Somebody who has no skin in the game.
Yeah.
Those kind of things. And he turned out to be a very good first witness. Again, although not dynamic in his testimony. So that was really interesting. And that letter, I mean, we kept coming back to it over and over and over again. Every one of their witnesses, we would ask them about, phrases and sentences and quotes from that letter, and they had no answer to it.
Was it Exhibit 1?
No, it wasn't. The contract was Exhibit 1. Yeah.
Okay, that's fair. Question, talk to us a little bit about advice of counsel as a defense. So sometimes we see this come up in bad faith cases, things along those lines. How does it apply to a case like this?
What's interesting is it doesn't, right? They tried. So frankly, they pled very limited defenses in this case, right? And their defenses were a moving target. And I think if there's one thing that I've taken from this case and working with Jason on this case in particular, it's being tenacious about those pretrial motions and educating the court about what your objections are going to be, right? Because they were all over the map on their defenses. And they were essentially trying to smuggle in an advice of counsel defense in a contract case.
Got it.
Advice of counsel is only a defense to an intent-based claim, right? You have to have, some sort of intent or knowledge element that your counsel's advice negates, right? That your counsel advised you could do this, so there's no way I could have intended to do anything wrong. In a breach of contract case, you don't have that. There's no intent requirement. And so we advocated for both in pretrial motions, in bench briefs, I think that there was at least one hearing in the few days before the trial that Jason handled, trying to push this idea to the court of like, they can't rely on this attorney to absolve them of a breach of contract claim. And slowly the judge came around to us, and we were able to, when we cross-examined that attorney, when they put him on the stand, we were able to really box them in. Right. And the judge issued a contemporaneous curative instruction in the middle of this attorney's testimony that you can only consider this testimony for the effect it had on the board members. The advice of counsel is not a defense. And so we were able to really kind of, through what felt to me at the time as over objecting, right, standing up in front of the jury and objecting repeatedly, but also having educated the judge so much before, and Jason having done so much work there, we were really able to box this guy in. And then we were also then able to create this closing argument of what all of this is really the result of is bad decisions that were the result of a bad attorney. And, at the end of the day, it actually, I think, ended up benefiting our case for them to rely so heavily on this attorney who was so obviously wrong.
So just so I make sure that I understand the law, because I will confess that I am not well versed. So if you had pled or had punitive damages or something like that on the table, then the advice of counsel would be relevant to that, to the intent behind punitive damages or like a fraud claim. But because this was just simply a breach of contract, if a lawyer says you're okay to breach the contract, the issue is just whether they breached the contract, not why they breached the contract?
Exactly.
Okay.
Right. And so I do a lot of whistleblower work, right? And so in those cases, a lot of times it's fraud on the government. And so you have to prove that they knowingly committed fraud.
Okay.
And you'll see a lot of advice of counsel defense in those situations, right? Because there is this knowledge element, there's an intent element that you have to prove. That doesn't exist for contract cases. And so we were very much able to, I think, use that to our benefit, where they thought it was a big benefit for them of like, this well-respected attorney that they had for years was, advising them that they could do this. When in fact, he didn't look at anything. He didn't do anything to confirm his opinions. He was just shooting from the hip, and he was wrong.
And so like, would a quick Google search tell you advice of counsel does not apply to breach of contract claims?
Yeah, a pretty quick one.
Okay.
A pretty quick one. And And, Clay's underselling it a little bit here, and I'll let him tell the story of his cross of the attorney Barry Arrington. What you have here during the depositions, what we heard over and over and over again, the president, the vice president, other board members who were deposed, is you could hear them saying a literal talking point given to them, I'm sure, by counsel was, well, Barry Arrington told us this was the way para worked. This is what para said. Well, Barry Arrington, in our view, was dead wrong. And the fact that all of these people relied on it, I almost feel bad for them, as voluntary board of director, members.
Yeah.
But at the same time, like para rules and para pamphlets are written in very plain English, right? They are intended for non-lawyers, and they lay out very clearly what para allows you to do vis-a-vis retirement and coming back. And all they had to do was read those themselves.
Yeah.
But instead, they relied on this lawyer who just led them astray. And so, during Clay's cross-examination, it was a joy to watch, because what Clay did was box him in, and Clay, I don't want to ruin the sort of climax here. Tell them what exactly this guy cops to on the stand.
Well, so we were able to run through all the things that he didn't review. And, my final line of questioning that we had thought about beforehand was, his interest in the outcome of this case, right? That he had a personal interest in this case being a good outcome, because if he didn't, then the school would have a claim against him for the effects of his incorrect advice, that he gave them the advice that essentially embroiled them in this lawsuit. And so, he hems and haws about, I don't know what you mean by personal interest and things like that. And then I asked him the final question of, well, have you put your professional liability carrier on notice, your insurance carrier on notice of a potential claim?
I'm on the edge of my seat about the answer to this question.
I had no idea what he would say, right? It's not a question that I'd asked at deposition. I just figured yes or no. It didn't really matter to me. I just wanted to be out there.
Right.
And he had. He had put them on notice of a claim, and that they were under, I think under a tolling agreement or something like that. And I just ended my cross-examination right there. I had like another page of stuff to go.
It doesn't get any better than that question.
And I just looked at it and said, I have no further questions, because I think it drove home to the jury this idea of, they were grasping at straws to try to find a reason to get rid of our client.
Yeah.
And they found it in this attorney who was just telling them what they wanted to hear, whether it was right or wrong.
So what was the end verdict? And because I know the answer to this question, did you get any interesting questions from the jurors as they were deliberating?
So I'll do the end verdict, and then I'll let Jason talk about the juror questions. So we got every dime that we asked for. So we went up there and we asked for the 3 years of her base salary under her 3-year contract, plus the value of the paid time off that she was promised under the contract. And it ended up being, God, you're going to put me on the spot here, I think it was $949,634.60, something like that. Right under $950,000. And so the jury, we asked for that from the jury. We weren't able to ask for the non-economic damages that we had hoped for, but I think that it was a good measure of the economic impact for her. And I'll let Jason talk about the deliberations.
Yeah, so Clay gave a great closing, and continued to use these text messages in closing with the poop emojis and the mean girl stuff back and forth. So the jury goes out, they get the case, Friday morning just before lunch. And I have told everybody I've worked with, like, if I had my druthers, closing argument would happen, and then I would fly to some remote island and have no ability to access the internet. And then I'd come back 6 months later and somebody would tell me the result. And because the waiting for the jury, and then when the jury comes in, it's literally the worst physical feeling I have. It's like
so true.
Driving by a cop doing 95 to the nth degree. Like it's way worse. But so we get a question. In all honesty, we were pretty confident. Instructions had gone well. The defense counsel had agreed and stipulated to an instruction that they had essentially the burden to prove that our client terminated the contract. And a jury question comes back, and I won't be able to quote it exactly, but it was, are we limited to the $978,000 or can we give more money?
God. In my dreams, it's like, can we have a calculator, or what if we want to award more than they've asked for? I don't know if I'll ever get that question, but oh my gosh.
Yeah, I mean, certainly by leaps and bounds, the best jury question I've ever gotten. And this
Wow.
jury was smart. I mean, the questions they asked a lot of questions of a lot of witnesses, and the judge allowed some and didn't allow others. And the ones that they, asked, even if they weren't actually asked on the record, were smart. They clearly knew what some of the legal issues that they weren't allowed to consider were. They were insightful, and they came back, basically after finishing their sandwiches, and gave us literally every dime we asked for.
Wow.
There's a couple of things that I want to throw in there real quick. We got that question. We had stayed to like tear down all the stuff and all the monitors and stuff. So Jason and I are there helping and working with our team to tear all that down. Defense counsel had gone to eat lunch. And so we see the question come out, and we like see the judge kind of look down, shake his head a bit, and say, "We've got a jury in question." And then we had to wait for defense counsel to come in from his lunch, and I don't know why he left again, frankly, after that question. But I mean, it was pretty impactful. I will say, one of the big things too that I learned in this case is to use your young associates, right? So Jason and I had a associate from our firm, Ingram Wilkinson, he's got the most stellar resume of probably anyone at our firm. He's just incredible background, incredibly smart lawyer, but relatively young, right? This was his first witnesses. He took a couple of cross examinations. He did a rule 50 motion when we tried to get essentially a ruling in our favor. The jury saw that, right? And they saw that we were allowing somebody with a little less experience to get up there and do their work and get the benefit of this trial. And I think they really appreciate it.
Yeah.
Right. You could see them actually paying a little bit more attention to him than, opposing counsel who obviously had been doing this for decades and was very, very good attorney. But, I think they were appreciative that we allowed a young attorney to have some time in court.
Wow, what a just phenomenal result. If people want to get a hold of you, so my first question, how do they get a hold of you, and what types of cases does your firm handle? It sounds like you're doing a lot of some business litigation. I know you all do super complex product liability, personal injury cases. So real quick, what kind of cases should people reach out to you, and how do they get a hold of you? Start with you, Jason.
Yeah, sure. I do not specialize in anything, despite everybody
Jack
telling
of
me
all
to.
trades, master of none.
Exactly. And so basically, I help anybody who's being screwed, and that can be personal injury, it can be employment, it can be defending a small business who is getting taken advantage of by a larger business. It's mechanics liens, it's big business commercial litigation, fighting that. It does run the gamut. And, you can email me at jason.wesoky@omtrial.com. I'd spell it for you, but that'd be boring. You have a Google machine, you can use it. Our phone number is 303-592-5900. But before we leave, I do want to make sure we get the Lebowski story. But go ahead, Clay.
Yes, the Lebowski story. And I mean, I hope my joke, there was no disrespect. Jason, he knows this, that I have such respect for Jason as an attorney. So absolutely phenomenal.
Yeah. So most of what I do is whistleblower adjacent. I represent a lot of whistleblowers in employment claims, retaliation claims, and then in key tam and bounty actions.
Okay.
So, folks who know about illegal conduct or fraud on the government or fraud in relation to securities filings, things like that, that's the majority of my work. I also do a lot of just run-of-the-mill employment work, right? Like this employment contract case. But we've represented some pretty high-level folks in discrimination cases, things like that. Our firm as a whole, though, I mean, we essentially run the gamut on the plaintiff side. We do everything from complex personal injury with a focus on brain injury work to complex legal malpractice cases on the plaintiff side.
Yeah.
Our partner, Michael Mim, and Nicole Quintana, they do just a phenomenal job with these complex legal malpractice cases. We've got folks here who do construction litigation for both subcontractors and general contractors, as well as on the homeowner side for construction defect. We've got folks who do wrongful death cases. Pete McClanahan at our office does an amazing job with medical malpractice cases.
Wow.
Then we've got Murray Ogborn, who he's done everything. And he's in the office every day I think he's 82 now, something like that. And he's just a wealth of information, but he takes everything.
Yeah.
Right. So, we do run the gamut. I will say it's entirely on the side of people who have been screwed. Yeah. Right. We do try to fight the man a bit here, even if we end up being the man in some situations. But, I think our firm's real focus is on trial. And I that's why I appreciate this podcast so much, is gives us the story to tell about a trial that we were successful.
Well, in that vein, we're talking about trials and stories in trial. Let's hear the Big Lebowski story. That's a great way to end.
Yeah. So obviously, big fan of the movie, The Big Lebowski.
Obviously.
And, it's funny because Judge Eliff, who presided over this case, his trial management order, his case management order, literally says in it, try to have fun. Like, this can be a fun profession. And so maybe taking that a little bit too literally, during the cross-examination of one of the board members, an attorney whose name is Linda Davison, who worked with my father at the Attorney General's office.
Wow.
I was asking her about some of these text messages, and one of the text messages said, Linda, I agree with Linda that Dr. Euchre is playing us. And so I asked Ms. Davison, I'm like, did you say that my client was playing you? And she goes, I don't know what you mean. And I said, well, let's look at the text messages. Here it says, Linda said, I agree with Linda that, Dr. Euchre is playing us. Did you say that? What'd you mean? And she goes, I don't know what you mean by playing us. And I said, in the normal parlance of our times, which is a deep cut from a Big Lebowski quote. But I know Clay got it because he had to bite his lip. He was right next to me. And then I'm fairly confident at least one of the jurors got it because he immediately leaned over to a fellow juror and kind of like whispered in her ear. So that was actually kind of fun. And Clay had the great idea, which I probably will do, in grabbing that piece of the transcript, maybe sending it to the Coen brothers or Jeff Bridges for an autograph.
I just think, there's such a practice pointer, honestly, in that not taking yourself too seriously and humanizing yourself to the jurors. So I love that story. Clay, Jason, thank you so much for taking the time out of your very busy lives to speak with us, and congratulations on an amazing verdict. And until the next one, we'll look forward to justice being served out there in the courtrooms all across Colorado. Thanks everybody for listening.
Thanks, Keith.
Thank you for joining us. We hope you've gained valuable insights and inspiration from today's Courtroom Warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.